Thank you, Mr. Chair. Thank you for the opportunity to present Senate File 730, which is about the Minnesota Data Practices Act. And the purpose of the Minnesota Data Practices Act is to protect the right of the public to know what the government is doing. This has long been our posture here in Minnesota. We believe in government transparency here in Minnesota. We believe in checks and balances. We believe in government integrity and accountability. And even when our government is not acting with integrity and accountability, we still expect that from our government. When it comes to transparency of government data, there are, of course, exceptions and competing considerations that must be balanced. But transparency is our default position and should remain our default position. The burden of proof should be on the party arguing that government data should be kept secret, not on the other party arguing that it should be made public. We are here today, and Senate File 730 is about a court case. My bill is quite simple, just 2 words added to the statute to clear up any confusion about the purpose of that statute. Prior to 2022, Mr. Chair, all of the Minnesota Attorney Generals had considered that data that was not on individuals was public unless it fell into another classification. But the Minnesota Supreme Court decision of Energy Policy Advocates versus Ellison changed that. In a split 4-3 court decision, the majority came to what I would consider rather an absurd conclusion that the legislature used the word individuals in section 13.65 to cover data that was not on individuals. This bill, Senate File 730, would return section 13.65 to its prior effect, returning the Office of Attorney General data that had been presumptively public for over 40 years to its previous public classification. So this bill simply fixes that court case and restores things to the way that they had been operating for decades before that decision. My bill's not getting at anything else. It does not mean that data on corporations or non-individual entities automatically becomes public. If another data classification exists, it will still be protected. And quite frankly, Mr. Chair, this should not be a partisan issue. Good policy is good policy, regardless of the individual that currently holds the office of the Attorney General. And my bill is just trying to restore the status quo back to sunlight and transparency. Because of this court decision, now data involving corporations or even the Attorney General's own data files regarding policy matters do not have to be released to the public, even if they don't contain any information about individuals. For example, if the Attorney General's office accepted money from an outside interest group to litigate a case, how would the public know whether or not that interest group is guiding the Attorney General's policy? Were non-taxpayer dollars directed to the Attorney General's office to influence the office to do something or to not do something? And there's a myriad of other examples here that the public just isn't going to be able to get at under the current status quo after the court decision. And these are questions that the people of Minnesota have an absolute right to the answers. So this means that more and more information is being hidden by the Attorney General on a variety of issues and policies. And because we do not have access to this information, we can kind of only speculate as to what they are withholding. And I would note the Attorney General did submit a letter in response to this, and in that letter, he gives us an idea of what they might be withholding. An example he gives us is that if a nonprofit corporation is aware of fraud, they will not risk filing a complaint because there would be a quote-unquote chilling effect on the nonprofit from even filing the report for fear of being identified. But Mr. Chair, I would submit that the Office of Attorney General's decision to withhold all of its inactive investigation data will mean that data underlying numerous high-profile Office of Attorney General investigations, including ongoing fraud cases such as Feeding Our Future, as well as other multiple inquiries, will be subject to withholding once these cases are closed. I would argue that this means we literally now have no idea what kind of fraud has been occurring and reported, and whether this Attorney General has just decided to sweep it under the rug. When it comes to government transparency, Minnesota used to be trust but verify, but the Attorney General seems to be saying now that it's none of your business. Minnesotans absolutely have a right to this information and to hold our government officials accountable. Minnesotans should be given the opportunity to understand how their Attorney General office operates, regardless of who holds that position and regardless of their party affiliation. This is a good government bill, Mr. Chair.